Now, 4 years after Apprendi, the Supreme Court had a second case, or another case in this line that I was personally involved in called Blakely against Washington. Now, Blakely against Washington, I'm going to suggest, was actually a hard case. At least a hard case for the court and a hard case for a constitutional, as a matter of constitutional interpretation. Because in the Blakely case involved a state sentencing guideline regime. And I think whatever you might want to say about the legislative action in New Jersey that gave rise to the Apprendi case, sentencing guideline regimes are certainly not intended to deprive the defendant of any rights. They're not intended to manipulate the burden of proof. What they are intended to do is to regularize criminal punishment and to give judges firm benchmarks for ratcheting up sentences when there are particularly egregious facts. And so it wasn't very easy for me as the lawyer to tell a story in Blakely that, oh, here we have sort of a historic kind of violation of the Sixth Amendment right to jury trial. We didn't even have sentencing guidelines or anything like them at the time of the founding, and so you couldn't stand there and say, well, hey, I've looked at the common law cases and they clearly say such and such. What I had to do as the lawyer was say, look, you established a principle in Apprendi that is based on originalist interpretation of the Sixth Amendment right to jury trial. Now that that principle is established, you have to apply it to these modern circumstances. And the reason why is because the same problems, even though unintended, will indeed rear their ugly head if you shirk from that responsibility. And so even though sentencing guidelines were perfectly well-intentioned, and in fact I actually support sentencing guidelines so long as a matter of regimenting sentences, so long as the facts are proved to the jury and not the judge. But once they're proved to the judge, you open up the real possibility for prosecutors to charge low-level offenses and get verdicts from juries that really only themselves expose the defendants to low-level punishment. And then you allow the judge to find, based on far less rigorous standards of proof, and only one person instead of 12, and an employee of the state instead of a citizen, to subject the defendant to far greater punishment. The effect is the same. And so in Blakely, the court, by the same 5-4 majority that had ruled in Apprendi, held that the Sixth Amendment right to jury trial applied to sentencing guideline regimes. And I'm sure, as most of you know, 6 months later, the Supreme Court said the federal guideline system was subject to the same infirmity as Washington State's system was. Let me outline now for you the confrontation cases, which I think you'll quickly see follow, I think, a similar story. The Sixth Amendment right to confrontation says that the defendant has the right to be, quote, confronted with the witnesses against him, unquote. But oddly enough, once the Supreme Court incorporated this right in the 60s and 70s against the states, it had sort of drifted away from that text and actually never made any attempt to tie it to any historical understanding of the Confrontation Clause. And so by the time we got to 1980, the Supreme Court decided in a case called Ohio against Roberts that what the purpose of the Confrontation Clause, at least as modern lawyers would understand it, is to guarantee the reliability of evidence through cross-examination. And so in a criminal trial, if the prosecution wanted to use out-of-court statements, what the judge should do is ask himself whether the defendant would benefit from cross-examination in this scenario. In other words, whether the evidence appeared to the judge to be reliable. And if the judge decided this looked like reliable evidence, then there wouldn't be any harm to the confrontation principle by letting it in without the defendant ever having a chance to ask a question of the witness who'd made those statements. And that remained the law for a generation. In 2004, I brought a case called Crawford against Washington, where I challenged that reliability-based rationale for the Confrontation Clause. And the first thing I said was, look, I've read this text over and over again, and I don't find anything about reliability or hearsay in the text. What I see is a rule about the way the prosecution has to present its witnesses' testimony. It has to bring its witnesses into court. so the defendant can have a confrontation. That is so the witness can say his or her statements in the presence of the defendant, in front of the jury, and be subject to cross-examination, and be under oath. And so what the Confrontation Clause is really about, as I put it and the court now has put it in Crawford, is about how witness testimony is introduced, in which, and we've now boiled that down to a concept of defining testimonial statements. If a witness's statements are testimonial, whether they be in court or out of court, the confrontation right applies. And so in Crawford, the Supreme Court got there through another opinion by Justice Scalia, and it was a very, very thoroughgoing originalist opinion. I've heard him use it actually as an example of what he thinks is a model of originalism in interpretation. And I'll just give one little autobiographical note on it, why I think that Crawford rests on such firm foundations. When I was researching to write the brief for this case, I was actually living in Seattle at the time. I spent one day, actually about a week, but one particular day I remember at the University of Washington Law School Library, where I was going through dusty old treatises and common law texts and the like, trying to discern how the right to confrontation would have been understood by the founders. And among those things I found an actual copy of the trial of Sir Walter Raleigh from 1603. It's an amazing thing, but there's a volume called Howard State Trials that collects the famous state trials from England from centuries ago. And you sort of gently open the book and the dust falls out. And what you find is almost a transcript of the trial. It's remarkable. And as I read through the trial of Sir Walter Raleigh, who the Supreme Court had acknowledged on many occasions, as had many scholars, that was one of the rallying cries for the right to confrontation, because Sir Walter Raleigh had been charged with treason and a co-conspirator had made statements while in custody that were introduced against Sir Walter Raleigh over his fierce objection to bring my accuser so I can confront him face to face. But they never did, and Sir Walter Raleigh was convicted and sentenced to death. And when I read through the transcript, I saw argument after argument that the prosecution had made for introducing the co-conspirator's statement that mapped on precisely to the arguments that were made in the modern day under the Roberts framework, that this co-conspirator hadn't been made any promises, hadn't been given any promises of leniency. He had implicated himself in the treason. He hadn't done it under pressure from the authorities, et cetera, et cetera. All these reliability-based arguments that were laced through modern jurisprudence in this respect. And I thought, boy, if I understand that originalism doesn't always give you the answer and that sometimes it's difficult to bring the past forward to the present for purposes of understanding what the Constitution means. But boy, oh boy, if you believe it all in history, this is the modern equivalent of what happened then. So again, I think Crawford itself was rather an easy case. And again, maybe I'll be taken on in that respect, but I think that was an easy case and the Supreme Court got it right.